Okay. Right, so good afternoon, everyone. Welcome to our debate on the question, how gendered is citizenship? My name is Laura van Waas. I am the Senior Researcher and Manager of the Statelessness Program here at Tilburg Law School. The Statelessness Program was established last year within the law school in order to form a center of expertise for research, training, and outreach activities on statelessness. It's very much an understudied issue. We're the first dedicated center of this kind in the world, but we're increasingly reaching out to partners who work on this issue around Europe and around the world and trying to bring their expertise here and also share some of our own experiences with them. This event is part of our outreach component of our program. We find it really important to try to make the issue visible to students, to members of the general public, and so that's what we do in the terms of organizing public events. Our first public event was our launch symposium held last November. That was looking at the human face of statelessness through photography, journalism on the issue of statelessness. For this second event, we wanted to choose a particular theme. And the theme of gender discrimination in nationality laws is very topical at the moment. For those of you who follow the blogs of, let's say, Hillary Clinton, you will know that she was in Geneva last December at an important meeting convened by the United Nations High Commissioner for Refugees to talk about issues of refugees and statelessness. And she dedicated about a third of her precious speaking time to addressing women's nationality rights. And she made a very public and a very impassioned call for states to reform their laws to allow women equal rights with men, to transmit their nationality to their children and to their spouses. So that's just to give you an idea that this is something that we haven't come up with as an academic fascination. This is an issue that is playing globally at the moment. It was the theme of UNHCR's celebrations of Women's Rights Day earlier this year. There is research ongoing within the UN and with a number of partners into this issue at the moment. And we want to shed some light on some of these recent developments, but also on the issues that underlie them. So our expert panel will talk about this in much more detail later, and after my words of introduction, I will be handing over to Mr. Sebastian Cohn, who works at the Open Society Justice Initiative in New York. This initiative is one of the most important NGO initiatives dedicated also to issues of statelessness and equality, and we're very privileged that he is with us today and has agreed to lead the discussion. But before I hand over to him, we have a short film that we'd like to show you that allows you to hear from a woman herself about how these nationality laws are impacting her and her family. Thanks.
أنا اسمي زينب الشهيب، تربيت بلبنان وما عندي جنسية لبنانية.
اوكي، هي كان حدا اعطينا الرقم لروح اقدم على شغل بشركه ميك اب وبارفان. بدهم الاكسبيرينس اللي انا عندي اياها وكل شيء طالبينه هن بالشغل عندي اياه انا، لانه انا كنت اوريدي اشتغل شغله سنتين ميك اب وبارفان باللي الدومين اللي هن بدهم اياه. رحت عملت الانترفيو كل شيء ومشي الحال، عجبهم كل شيء ومضيت كونترا وخلص على اساس اوكي مثل ما انا بدي الشغل ومثل ما هن كان بدهم، يعني كل شيء كان مثل ما بدنا اياه. وصلت عم بمضي مضيت الكونترا وخلص على اساس بدي امشي. قالت لي بدي هويتك. لا اخذت ولا عطت ولا حتى جربت مثلا تفهم شو هي ولا شيء، مجرد انه مش لبنان، يعني ما معي هويه لبنانيه، خزقت الكونترا قدامي وكبته. انا ما قلت لها، انا غصيت وجيت على البيت بكياني بصراحه، يعني ما قدرت اعمل غير هيك. شو رأيي بهيدا الشيء؟ رأيي كثير شيء مش حلو. يعني برجع بقول لك، يعني الإنسان ما ينوجد أشرف له من إنه ينوجد بلا هوية. مش بس شكلت العقل بكل شيء، للجواز وللعمل ولكل شيء. حتى أوقات مرة كنا طالعين على الجنوب، مجرد لأنه بالمنطقة اللي طالعين عليها في UN اضطرينا نحكي مع الشوفير الباص انه يمرقنا بلا ما ياخذوا هويات. لانه اذا لو بده ياخذ الهويات كنا توقفنا هونيك ورجعنا. يعني حتى بقلب بلدنا بلبنان ما فينا نتنقل مثل ما لازم. اشتغلت بعدة مطاعم، بس كمان كنت مثل ما كان يصير مع اختي، معاشي غير معاش غيري، مع انه شغلي يكون اكثر من شغل غيري. قبل كنت لوم اهلي، كنت لوم امي انه انت ليه تجوزتي، بس كمان برجع بفكر فيها بقول انه هن بايامهم ما كان عندهم هيدي المشاكل، قصه الهويه، قصه انه ما كانوا يفكروا بهالطريقه انه ما في هويه. هلا بلوم الدوله. يعني بقول لك بتحسي انه انسان موجود شكليا، نفسيا روحيا مش موجودين، لانه ماني قادره اعمل اللي انا اللي بدي اياه، انا عايشه هيك خلص، انه انا عايشه.
حكيتنا انه انا اخذي واحد مصري وما فينا ناخذ جنسية لبنانية، وهيك حكيتنا انه كان كل شيء صعب علينا نحن لانه ما معنا هوية لبنانية. يعني بال900 مليون 950 هيك كلهم بياخذوا رفقاتي انا، لاني انا ما معي هوية لبنانية وما معي هوية، هني معهم هوية بياخذوا معاشات مرتبة، أنا أجنبية بعتبر. ما بفكر فيها الجاز إنه أتجوز وأستقر وهيك، ما بفكر كرمال هوية لبنانية. لا أكيد بدي هوية لبنانية، جنسية لبنانية تكون معي، روح أتوظف غير هالشركة معاش مرتب، روح انه مطرح ما بقدر روح، مثلا ما حدا يوقفني، ما حدا يحكي معي، لا بهمني اشتري سياره يكون معي دفتر السواقه، بهمني انه يكون معي هويه لبنانيه. انا هلا بالحساب انه ماني عايش، بس ماني عايش، ما معي هويه لبنانيه.
All right. Good afternoon, everyone. I want to start just thanking Laura and the Statelessness program for putting on this event. I think it's fantastic to it was fantastic to be invited to moderate this session with eminent guests, and it's fantastic to see this research center developing, and it's been a great pleasure to work with you. At the end of the Second World War, gender discrimination in access, conferral, and loss of nationality was the norm around the world. Today, the situation in many places is radically different. Women have gained equal rights to men, at least on paper, and states are more conscious about the importance of both avoiding and preventing statelessness. Still, almost 30 countries, maybe more, maintain discriminatory laws. In some places, women are unable to pass nationality to their children, or they cannot obtain identity documents for themselves without the presence of their husbands or their fathers, or they may lose nationality if they marry a foreigner. So these are some of the issues this panel will discuss today. So without further ado, I want to introduce our three panelists. To my left is Professor Kees Flinteman. Kees Flinteman is presently an honorary professor of human rights at Utrecht University and Maastricht University. In 2010, he was elected as a member in the United Nations Human Rights Committee. And before that, he was a member of the United Nations Committee on the Elimination of Discrimination Against Women, the CEDAW Committee, from 2003 to 2010. We have Rada Govil. Rada Govil works in UNHCR's Statelessness unit in Geneva, where an important part of her work is on preventing gender discrimination in nationality laws, which can lead to statelessness. Last year, she helped organize a roundtable dialogue in Beirut with women from the Middle East and North Africa to better understand how they and their families have been affected by gender discriminatory laws that deny mothers the ability to pass their nationality to their children. Rada is also currently co-writing a chapter on women and statelessness in a forthcoming publication on nationality and statelessness, co-edited by Alice Edwards and Laura van Baas. And next to Rada, we have Professor René de Groot. René de Groot teaches private law, comparative law, and private international law at Maastricht University, where he also obtained his Doctor Juris degree. René de Groot has published many books and articles on comparative nationality law. In 2008 and 2009, he was the expert consultant for the preparation of Recommendation 2009/13 of the Council of Europe on the position of children in nationality law. In 2011, he wrote, on invitation of the UNHCR, a discussion paper on the 1961 Convention on the Reduction of Statelessness, in particular on the access to nationality for otherwise stateless children. And he has worked on the UNHCR guidelines on the interpretation of Articles 1 to 4 of the 61 Convention. So the style of the panel debate today will be first a session where I will throw a whole lot of questions at our panelists. And after that, we're going to open up for a general Q&A session with the audience. So I want to start just with sort of the general framework and ask, I think I will direct the very first question to Case. I want to ask what it is, in fact, we're talking about when we speak of gender discrimination and citizenship, and what the different forms of discrimination we see. Obviously, we've seen some of it already in a video, but and then if you also want to chip in, that would be great.
Well, thank you very much, and let me start by expressing my great appreciation for this initiative, for the work undertaken by the Center here on issues of statelessness. I do hope and I do expect that the work in the academic field will contribute to the elimination of this particular pernicious form of gender discrimination still existing in different parts of the world. I very much see the issue of today as a human rights issue, and that was also clear, I think, from the two women who spoke in the film, because they made it clear that not having a nationality is making them outsiders, does place them outside the society, does not give them the opportunity to belong to the community. And it's from that perspective that I've witnessed the impact of statelessness, of not complying with the obligations member states of the United Nations have around the world with the basic obligation of realizing gender equality. The chair, the moderator, already referred to the end of the Second World War. I always find it very interesting that at the end of the Second World War, in the preamble of the United Nations Charter, there was a reference to the confirmation of faith of the international community at that time to the equality of women and men. And I can tell you that at that time, that was certainly not a reflection of the reality on the ground, but it was a revolutionary message. A revolutionary message covering many, many fields, because in all countries around the world, including in this country, gender discrimination is very deeply, deeply rooted in history, in culture, and in religion. We have made some progress, among others, through the Convention on the Elimination of All Forms of Discrimination Against Women. That's the only human rights instrument explicitly referring to the issue of nationality. It was felt in the 70s that for women this was one of the most important issues to be addressed by the international community. and to be monitored by the international community to see to it that states would give women the same rights as men in the context of nationality, that women should be given the same rights as to the transfer of their nationality to their children, the same rights as men have. Later on in the discussion, I can further relate on my experiences within the Women's Committee, but this is certainly the issue of the transfer of women married to foreigners of their own nationality to the children, one of the important forms of discrimination against women in the context of nationality. There are many more, but this is certainly one of the most important. I do think we have made some progress in this field, given the fact that we have 186 states parties to the Women's Convention who have all accepted to be accountable to the international community of what they have done in order to comply with Article 9 of the Convention. But, as said, we still have problems. And once again, my hope is that the work of the center here and the work already undertaken in the context of different organs of the United Nations will also lead to a situation in which women can fully enjoy their rights also in this context. Let me stick as later.
Thank you. Would either of you like to address the question of what it is we speak about when we talk about gender discrimination and nationality?
I think, Sebastian, it's very important to realize that traditionally there was a huge gender discrimination in nationality law. If we go back to the end of the 19th century, the principle was that every person should have one, but only one nationality. We call it the so-called unitary system, which had as a consequence as well that within one family, one only should have one nationality. And that was, of course, the nationality of the husband. At that time, it was so that all jurisdictions provided that if a woman married a foreigner, she would automatically lose her own nationality. And nearly all jurisdictions said that she would automatically acquire the nationality of the husband. Therefore, man and wife had the same nationality. And this nationality was also transmitted to the children. If the husband changed his nationality, it was nearly in all jurisdictions so that the woman lost her nationality as well and acquired a new nationality. Now, we can see that there were huge disadvantages of this system. In particular, after the First World War, we had a lot of cases of statelessness. If a woman would marry a stateless person, she would lose her nationality and would become as stateless as her husband. And of course, the children would be stateless as well. And then, during the 20s, some states, the 20s of the past century, some states realized that at least one should avoid cases of statelessness. And that was the first step taken into the direction of some equal treatment. And that is already reflected by the 1930 Convention on some conflicts of law in relation to nationality, the Hague Convention on nationality issues. There, the convention prescribed that a woman who would not acquire the nationality of the husband would keep her original nationality, would have a nationality of her own. But it is also interesting to see that in the 30s, one could already notice that this Convention on nationality issues of 1930 was only ratified by a quite low number of states. And I came across a commentary on human rights and international law published in the 30s, where a former, I think it was a former Vice Secretary General of the League of Nations said that the fact that this 1930 convention is ratified by such a low number of countries is mainly due to the fact that under circumstances women can have their own nationality. By the way, the Kingdom of the Netherlands ratified the 1930 Convention with a reservation precisely on that point. And ladies and gentlemen, the reservation is not taken back yet. It still exists. Now, I could continue about this point, but as a kind of introduction, we should keep in mind that this unitary system was a starting point, and that that it took many, many years until we, at the end, got a dualistic system, where both spouses can have their own nationality, and then as prescribed in the CEDAW, both spouses must have the possibility to transmit their nationality on a non-discriminatory way.
Thank you. I mean, these are of course all issues that we'll have more time to elaborate on as we continue the discussion. But I wanted to raise, maybe with you, Radha. Kees did a great job of placing this issue in a human rights context, and we've talked about some of the relevant conventions and the fact that this form of discrimination remains in nationality laws today. At the same time, we have also seen reforms, but I was wondering if you would be able to elaborate a little bit on the importance of law versus practice, and how, you know, even in places where we see equality in the law, that's not necessarily what's experienced by women in real life.
I think that that's a really valid point, because what's in the books is not often what occurs in practice. What, as UNHCR, we've done recently is an analysis of countries around the world that maintain gender discriminatory laws on their books, and the results have been quite interesting. At a first thought, many people might imagine that a lot of gender discrimination occurs in particular regions in the world. And one of those regions that often comes up is countries which have Islam as the basis of their religious basis. But what our analysis revealed was that it was not just restricted to countries in the Middle East and North African region. In fact, gender discriminatory laws exist almost all around the world, including in Europe. Monaco was the last country in Europe, as late as last year, to reform gender discriminatory provisions in its law. But you do find that countries that have gender discriminatory provision exist in sub-Saharan Africa. There are 4 countries in Asia. There are even 2 countries in the Caribbean. So it is a worldwide issue. But to the point that you might see certain provisions in laws which purport to gender equality, or at least have provisions which suggest that in certain circumstances women may be able to pass on their nationality, for example, to their children. When you look at the practice of these countries, the situation is very different. So take, for example, the situation of Kuwait, which does not have gender equality in its nationality laws when it comes to the transmission of nationality from a mother to her child, but does say that where a woman has a child with a father who is either stateless or unknown, a child may be able to acquire Kuwaiti nationality, her Kuwaiti nationality, but that is only upon a decree issued by the Ministry of Interior. Now, if you've been to Kuwait, you'll know how virtually impossible that is, and in fact it is impossible in practice. Similarly, in Nepal, the law, again, over there requires that if a woman has a child with a father who is stateless or unknown, there are possibilities for the child to acquire Nepalese nationality. However, in practice, we haven't seen a single situation of naturalization in Nepal where a woman has been able to pass on her nationality in practice. So you do need to look at both the situation of what's the law on the books, but more importantly, what happens in practice and the hurdles that women face in practice in being able to exercise their rights.
Thank you. I wanted to turn to just to take a few steps back, Renee has already addressed some of the historical, the history around gender discrimination and nationality. But I was wondering if you could tell us perhaps a little bit more about when states began to regularize citizenship more generally, and why women, for the most part, were not given the same rights as men to start with.
I think historically spoken, one of the reasons that women were discriminated in nationality law was this principle: one should have only one nationality. And therefore there is a relationship between the discussion on, enabling persons to have dual citizenship or multiple citizenship and the gender discrimination issue. When did states change this attitude? It's very interesting to see that some states changed this attitude much earlier than others. If it comes to the automatic acquisition of the nationality of the husband, it is very striking that in particular in Latin America, and I do not know precisely why, already some countries in the end of the 19th century said no automatic acquisition. And it is precisely Latin America as well where we can see that as early as 1933, a convention was concluded on the equal treatment of men and women in nationality law. Quite early was as well the United States, 1922, and the Soviet Union, 1919. But then it took a long time until other countries made the same step. I think for Western Europe, one can say that most countries in Western Europe only undertook action after 1970. And of course, there is a close relationship with the adoption of CEDAW in 1979. Of the larger countries in Europe, the last country which made the nationality law completely in conformity with the equal treatment of men and women was Switzerland as late as 2006. And Monaco is still not in conformity with the equal treatment of men and women. And of course, Vatican City as well. They have a nationality act, and they even are able to pass the nationality by jus sanguinis, by descent, but they are not that active in that field.
So I was wondering, Case, perhaps if you have anything to add to that on sort of the events and factors that propel changes over time, in respect to nationality, of course, but also perhaps more generally, equal rights between men and women.
When you think about the deeper lying reasons for discrimination against women, I think we have to bear in mind that most societies in the world, if not all societies in the world, have a patriarchal structure where the role of women is very much related to the care of the children, where the role of the women is subject to the role of men. That particular problem is also addressed in that, in my opinion, still very revolutionary convention. That's the Convention on the Elimination of all Forms of Discrimination against Women. That's such a very interesting and very remarkable convention, because it also obliges all states that are parties to that convention, and that is the large majority of all states in the world, to address the issue of the cultural cultural religious practices which stand in the way of full equality of women and men, to eliminate stereotypical thinking about the role of women and men. I think that's a deeper lying reason. And for that reason, it is so difficult to change. It's not a change overnight. It requires not only legislation, but a broad range of policies and programs in order to change the mental attitude. And in that sense, I do disagree a little bit with Radha. She said, well, it's important to have the law in the books, but it's even more important to look at practice. Yes, I would agree. For a lawyer, for anyone, it's important to look at practice. But now the situation is different, because for the first time in the history of, I think really in the history of the international community, we do have the criteria to assess what's happening in practice. And that is, those are the provisions accepted by, voluntarily accepted by all states around the world, to strive for the full equality of women and men in all fields, including in the nationality field. And to come up and on the basis of that assessment to advise states, to recommend states, to urge states, to put pressure on states to pay respect to their international obligations. And for that reason, it is, I think, equally important to look at practice, but at the same time to be aware that that practice can now be assessed on the basis of internationally agreed standards.
I thought I'd just add a point about the evolution, I suppose, of national laws and what's happened in terms of recognition of gender discrimination in nationality laws being a problem, and those countries that have undertaken reform. And I think it's interesting to see that there are still at least 26 countries worldwide that continue to discriminate against women in terms of their ability to pass on nationality to their children, and possibly up to over 40. We still have to complete the analysis in relation to gender discrimination when it comes to the acquisition, change, or retention of nationality of women. And you think, goodness, you know, we've had CEDAW for a while. We've had a huge and very successful women's rights movement. How can it be, and what are the justifications for continuing gender discrimination in nationality laws? How has this been allowed to exist? And it's interesting also, I think it's important to understand the arguments typically raised by states to continue and retain these measures in their laws. And we were having an earlier discussion about the role that religion might play in holding on to some of these laws, and how that can be quite a fallacy. There are those who argue that, for example, it is enshrined in Sharia law that women are subordinate to men, that women do not have an equal right to nationality. But there is considerable scholarship out there on Islam, Sharia law, and nationality, which has shown that, in fact, there is no such basis in Sharia law. It's a matter of interpretation. And, in fact, many of the countries, say, for example, in Middle East and North Africa, which do retain gender discrimination in their nationality laws, in fact, implemented these provisions precisely because they were provisions that they inherited from their colonial predecessors, often who were either from common law jurisdictions or civil law jurisdictions, both of which had a very strong gender discriminatory component to their philosophy and passed that on. Now, those laws just happened to conveniently fit in within a pervasive patriarchal society that existed elsewhere, and was therefore codified into law, which was subsequently not changed post-independence, despite women playing such a strong role in achieving that independence. So these arguments that it would be inconsistent with Sharia law fall flat, and in fact you see disagreement between countries. You have, for example, a country like Pakistan, which argues for gender equality in nationality matters on the basis that women under Islamic law have the right to have custody of their children. On the other hand, you have other countries which simply say, no, the lineage is through the father, and that's where the story ends. So I think that it's interesting to look at gender discrimination on a country-by-country basis, to understand the reasons why it continues to exist, in order to be able to then argue why it should be reformed and changed.
If you allow, Sebastian, I add one point. I agree completely with Radha. Recently, I had the opportunity to check precisely the history of the reservations on CEDAW, in particular on Article 9. And it is very, very interesting that indeed a number of Islamic countries made a reservation on Article 9, but none of the countries refer to Sharia. They refer to the law in force in the country. often inherited by their former colonial powers. But they do not say it violates Sharia. And that gives hope, of course.
Yeah, and in that respect, maybe for the audience, it's important to know what Article 9 is about, because otherwise, yes. And let me read it. Article 9, paragraph 1 relates in general to the equal rights of women and men in the context of nationality law, and it reads that states parties shall grant women equal rights with men to acquire, change, or retain their nationality. They shall ensure in particular that neither marriage to an alien nor change of nationality by the husband during marriage shall automatically change the nationality of the wife, render her stateless, or force her upon her the nationality of the husband. That's paragraph 1, very, very important. And again, I would like to emphasize, it were women, it was the women's movement in the 70s addressing and highlighting this issue as a human rights issue. And secondly, in Article 9, paragraph 2, it says that states parties shall grant women equal rights with men with respect to the nationality of their children. So there is no doubt about the clarity of the obligations that 186 states around the world have accepted. And that's important to realize in all discussions. It's not only a political discussion, it's also a legal discussion. It's a discussion about the compliance with international law and the compliance with human rights. Taking up the point by René de Groot, I would have no problems of holding any reservation, and there are some such reservations, to Article 9, paragraph 2, as incompatible with the object and purpose of the Convention. I do think that such reservations are impermissible, and that has always been also at the front of the role of the CEDAW committee, to call upon states, parties to the Convention, to withdraw such reservations in order to urge them to fully comply with their obligations.
May I add a point? I agree with Kees Flinteman, and one can see that some countries expressly protested against reservations. And for example, Algeria made a reservation, and Sweden, Portugal, Denmark said it is not compatible with the aim and purpose of the Convention.
Thank you. I want to get back to CEDAW and what CEDAW has done in more detail later on. First, I just want to, several of you have referred to recent reforms, and I wanted to ask you, Radha, more concretely, what are some of the reforms we have seen recently in this area?
As I mentioned, we've recently done an analysis to look at what's going on around the world, particularly on the issue of a woman's right to transmit her nationality to her child. And I suppose this is where a key link to statelessness arises. And if I might just quickly give a little background of that to then explain how reforms are important and what they actually do. For those of you who aren't necessarily that familiar with statelessness, it's a condition of not having the nationality of any country, not being recognized by a state to be a national of that country, and can, as you saw in the video, have some pretty devastating impacts on those who suffer it. In fact, in almost all areas of their life, because nationality links you to many human rights and many essential rights to allow you to be a functioning member of society. So where women are prevented from passing on their nationality to their children, statelessness can arise for a number of reasons. And this can be where the father is himself stateless, as can be the case in many situations. It can occur where a father is a foreigner and unable to pass on his nationality because, for example, his country provides that in order for him to pass on his nationality, the child needs to have been born in that country. So where the father is a foreigner in a different country, the mother is stateless, the child cannot acquire any nationality and is therefore stateless. It can also occur in situations where a father needs to undertake a process, as occurred in the video. They have to go to a consulate to register the child. If the father dies or abandons the family or for some reason just doesn't do it, the child is left stateless. there can be situations where the father is forcibly displaced or removed from the family. There are myriad reasons where if a father is unable to pass on his nationality, which is the presumption, and a woman is unable to because of gender discrimination in the nationality law, the child is the one that suffers. And as a result, the woman suffers as well, because as the primary caregiver in these situations, they have to take on a lot to ensure that a child is being cared for and able to access rights to kids who are nationals. So you have situations where, thankfully, the law has been reformed in this particular instance to ensure that women as well as men can pass on their nationality to their children on equal terms. And we've seen reforms in many, many countries. In the last 10 years, we've had countries as diverse as Sri Lanka, Egypt, Algeria, Indonesia, Iraq, Sierra Leone, Morocco, Bangladesh, Zimbabwe, and very recently in 2010, Kenya, all to varying degrees remove gender discrimination from their nationality laws. A good example of a reform to nationality law was in Morocco, and I actually have the Moroccan before and after provisions here. So it provides quite a good comparison. When you actually listen to the legislation, it makes it very clear how it is that legislation has been reformed. So the original article, the original Moroccan article, that was discriminatory, used to read, if I can find it here, so Article 6 of Decree 158/250 said that a child is deemed Moroccan, a child born to a Moroccan father, or a child born to a Moroccan mother and an unknown father. So only making provision for a mother to pass on her nationality where the father was unknown. That provision was reformed by the law of 2007, which in Article 6 said a Moroccan, quite simply, is a child born to a Moroccan father or a Moroccan mother. More importantly, though, the law was progressive enough in that it actually instituted some transitional provisions to catch those children who had not acquired nationality from their mothers prior to this amendment taking place. And in fact, the transitional provision says the new provisions on the allocation of Moroccan nationality under this article by the birth of a Moroccan mother are applied to all persons born before the publication of this act. So it was a retroactive provision, which meant that all children who were stateless beforehand, but who can now acquire nationality through their mothers, can do so. And we had a particularly, as I was saying, it's nice to see the law in the books, but it's also nice to see the law in practice. Recently, we organised a roundtable discussion with women in the Middle East who had suffered the impacts of discriminatory nationality laws, and one of the women who attended our dialogue was a woman from Morocco who told us the story of how she had married an Iraqi man who was unable to pass on his nationality to the children. And as a result, her son, who was born at the time the old Moroccan law was in place, was stateless. Subsequently, as you know, the law was reformed, and she had a daughter. And she went to have her daughter registered as a Moroccan national, which happened in due course. But the authorities were so keen to ensure that their new, better non-discriminatory law was applied that they actually noted that she had had a son, inquired about his status, and duly accorded him Moroccan nationality so that he was no longer stateless. So a really fantastic example of a state taking very proactive steps to ensure that reforms are actually implemented in practice. Now the trick is for the woman to be able to transmit her Moroccan nationality to her Iraqi husband so that they can all live together in Morocco. But that's a challenge she's working on at the moment.
Thank you. Case, you referred previously to the importance of women's movement, the women's movement generally, in sort of achieving more equality. I was wondering if you or anyone else could just be a little bit more specific about sort of the successful arguments and strategies that have been used to kind of achieve this change that we've seen, at least in some places.
Shall I start? René? My point is always, if we wouldn't have an international women's movement, an international well-organized women's movement, there wouldn't have been a women's convention. There's no doubt about it. It's because of the pressure of women's organizations around the world, both international and domestic women's organizations around the world, that there is such a convention, that we have a bundle of standards by which to assess state performance. Likewise, I very much like the examples just given by Rada of countries that have changed their nationality laws. I've seen them all before the CEDAW committee explaining their laws, their legislation, and also addressing their discriminatory legislation. I do remember in all cases, except Iraq, I haven't seen Iraq, in all cases that we have raised in the CEDAW committee pertinent questions on such discriminatory legislation in the field of nationality. We could do it, and there I come again to the role of the women's movement, because of strong domestic women's organizations in Morocco, in Egypt, in the Lebanon, in other countries as well, who have given information to the CEDAW committee on the negative impact, the negative consequences of the existence of discriminatory laws. That helps. In criticizing, in dialoguing with the state party concerned, in exposing that the state party concerned, for example, Morocco, is not living up to its international obligations, in recommending to the state party that it has to improve its record. And such recommendations are then, and again, there I come to the role of women, the women's movement, are taken up, not necessarily by the state itself. States are inclined to put any recommendation in drawers, to forget about them until the time that they have to report again. No, they are taken up by the women's organizations, pressurizing the government of the day, the legislature, to indeed take into account the recommendations made by the monitoring body. And for that reason, the women's organization, both domestically and internationally, are tremendously important in putting pressure on states to live up to the equality of women and men principle, which was enshrined in the United Nations Charter in 1945. Very important indeed. And not only there, but also in the context of assisting women victims of violations of their rights, including in the field of nationality, to take up their cases if the state party has recognized that in individual communication procedures. But maybe we will discuss that at a later stage. But no doubt, the organized women's organization, the organized women's movement, tremendously important.
Yeah, historically spoken, one can see that very well in the United States. After women got voting rights, women were confronted with the fact that if an American woman in America married a foreigner, she lost her American citizenship and could not vote anymore. Whereas her neighbor, who just arrived from Europe and did not speak one word of English, got voting rights because she married an American. And that was the very starting point of protests of women organizations in the United States to defend the point of view that women should have a nationality of their own. There's a very interesting book published a couple of years ago. I think the author was Brett Benner, A Nationality of Her Own. And then, of course, the next question is, if women can have a nationality of their own, why shouldn't they be able to pass this nationality to the next generation? And we saw in the film that this Lebanese mother could not pass her nationality to the children. Why not, if the children grow up in Lebanon?
Just thought I'd add a practical example. I think what Kees was saying about the action of the international women's movement, but also the local women's movement has been instrumental in achieving change. And as part of the dialogue that we organised last year, we had a day where we talked to women and women's rights NGOs in the region, in the MENA region, who have sort of banded together under this campaign for a woman's right to nationality, or nationality rights for women in the MENA region. And they have had spectacular success. They have taken very grassroots methods, the typical methods of protest, of getting out in the street, often at quite considerable personal risk, but also a hugely educative role for women in the society who perhaps would not question, who have been conditioned to believe that this is the status quo is okay, that one should not expect that as a woman I have the right to pass on my nationality or to retain my nationality or so forth. And the organization that we worked with in Lebanon, called the Collective for Research Training Action, has created a network, if you like, of women's organizations that have undertaken some pretty radical but also effective actions. And one of those actions that took place in the case of Morocco, which was very instrumental in achieving the reform there, was the creation of what they called listening centres. They were aware that women who were affected by discriminatory laws were not just city dwellers. They existed all across the country and had different experiences of the impacts of statelessness caused as a result of the discriminatory laws. So what they did was they actually went around the country and established these mobile listening centres, or legal clinics, if you like, where women could come and express, tell their stories basically about how they had been impacted. These testimonies were created and a huge bank of stories were collected, and that was a key plank in a submission to the government to get the law to be changed, to show how widespread the issue was and to show the diversity of women who were being affected. So quite a simple but effective strategy, and one that I think other countries in the region who wish to emulate the achievements in Morocco in terms of reform are also going to implement.
So the title of the panel today is How Gendered is Citizenship? And obviously, some of the most severe forms of discrimination in this field is against women. But we see also today that there are subtle forms of discrimination against men in nationality laws in some countries. This tends to be mostly an issue of prohibited or complicated transmission of nationality from the father to the child, where the child is born out of wedlock, for instance. I wanted to ask you, Renee, if, well, first of all, is this a problem? And if it is, how do we go about addressing it? And I was wondering also if you wanted to perhaps address this in the context of the Genovese versus Malta case.
Thank you, Sebastian. In the first place, I want to say that it is a problem also in the Netherlands. The Netherlands law is discriminatory in that point. A child born out of wedlock with a foreign mother and recognized by men of Netherlands nationality does not always acquire the nationality of the Netherlands. If the child is recognized before the child reaches the age of 7 years, it gets automatically Netherlands nationality. But if the child is older than 7 years, the evidence has to be delivered that the man who recognized the child is indeed the biological father of the child. And that has to be done by a DNA report, where with a certainty degree of 99.99%, it is proven that the man who recognized the child is the biological father. And this has to be delivered within 1 year after the recognition. I just got an email of a lawyer who was confronted with the fact that the DNA report was only submitted to the Immigration Naturalization Department after 13 months. And now they refuse the Dutch passport to the child. I said that, in my opinion, this is a clear discriminatory rule, And now I'm very happy to be able to say that it also violates the European Convention of Human Rights. There's a very interesting recent decision of the European Court of Human Rights of the 11th of October 2011 in the case of Genovese against Malta. And the core facts were the following. Mr. Genovese is a Maltese national. He had a very short relationship, must be extremely short, in Scotland with a British national. The result is a baby is born. And the mother managed to get, at least under Scottish law, the name Genovese on the birth certificate of the child. Now, this was in first instance not recognized in Malta. She started proceedings in Malta, and then also, according to Maltese law, it was recognized that the Maltese Genovese was the father of the child, and therefore the child now also has the family name Genovese. Then the mother said, I want to have a Maltese passport for my child. No, the Maltese authorities said that is not possible because according to Maltese law, only the children of Maltese mother get always the nationality of Malta, and the children of a Maltese father only in the case only in the case the child is born within wedlock or so-called legitimized. And legitimation implies that the father must marry the mother. Then one gets legitimation. It's not a rule invented by Malta, by the way. In the past, it was also in the law of the United Kingdom. Here we also can see and can notice that the former mother country influenced the rules in the former colonies. And then the mother complained about that, went for court in Malta. In first instance, she got right, but then in appeal, the courts of Malta said, no, it is not discriminatory. In this case, there is no close link with the child, and therefore the application rejected. Then she went for the European Court of Human Rights. Now, an interesting point is, it is evident this is discriminatory, but is the access to citizenship, the access to nationality, a right protected by the European Convention on Human Rights? Nationality is not mentioned. Then the mother first argued, but it is the access to nationality is protected under the family life issue of Article 8 of the European Convention on Human Rights. The court came to the conclusion that there is no family life between the child and the father because there was this very brief contact with the mother, which caused the existence of the child, but the father refused any contact with the mother and the child, no family life. Then the lawyers of the mother said, but the access to citizenship or not influence, have an impact on the social identity of the child, and the social identity is covered by private life under Article 8. And there the court said, yes, that's true. That is true. And therefore came to the conclusion that Malta violated the combination of Article 8 and 14 of the Convention, and therefore had to give access to the nationality of the child, had to give to the child access to the nationality of the father. That is extremely interesting. The court said also that Malta went beyond his obligations to provide for a jus sanguinis acquisition in case of birth abroad. It is not so that a child always has the right to get the nationality of a parent. But if one gives access to the nationality of a parent, it must happen on a non-discriminatory way. And therefore I said to this lawyer in the Netherlands as well yesterday, go for Genovese and Malta, and say that the requirement of requiring DNA evidence violates the principle derived from the European Court of Human Rights in Genovese, Malta. Because it is never so that the mother has to prove the DNA type with the child.
I didn't know this case, and I would have advised the British lawyer to have addressed the Human Rights Committee rather than the European Court of Human Rights. But then I realized that, unfortunately, the UK has not recognized the individual communication procedure under the Covenant on Civil and Political Rights. So no way, because it would have been somewhat easier, I think, and I do hope that we will get. And now I'm speaking as a member of the United Nations Human Rights Committee supervising the Covenant on Civil and Political Rights. I do hope that we will get a case like this, because under the Covenant on Civil and Political Rights, it's somewhat easier to address this issue because we have an autonomous right to non-discrimination under Article 26. So there is no requirement to prove that the discrimination is related to any of the rights enumerated in the covenant itself. And so your lawyer, your Dutch lawyer, René, may still opt for the Human Rights Committee to have a similar decision of the Human Rights Committee. And saying that, I can say this because as a Dutch member of the Human Rights Committee, I'm not allowed to participate in the decision-making of the Human Rights Committee on Dutch cases.
So actually I want to open up very soon for questions, but I have two myself before. You just talked about the Human Rights Committee, and both Radha and you represent or work with institutions or bodies that try to address the issue of gender discrimination and nationality. So I wanted to start with a question about both CEDAW and the Human Rights Committee and what these bodies have done in order to address these problems. And also in connection with that, we heard before that some states have entered reservations to Article 9 of CEDAW, and you also mentioned that you thought that these kind of reservations are impermissible in light of the object and purpose of the treaty. And I wonder, in sort of very practical terms, what that means and how advocates like my own organization or indeed others can work with these type of arguments to remove reservations to Article 9.
Shall I start? Or would you like to start? Yeah. The question is about the Human Rights Committee and the Women's Committee, the Committee on the Elimination of Discrimination Against Women. I don't know how well aware the audience is of the human rights treaties, but very briefly. The Human Rights Committee is a committee of 18 independent experts supervising, monitoring the compliance, the implementation by states parties 168 of their obligations under the Covenant on Civil and Political Rights. The Committee on the Elimination of Discrimination Against Women is a committee composed of 23 independent experts, and I've been a member of that committee for 8 years, supervising the convention with the same name, the Convention on the Elimination of All Forms of Discrimination Against Women. Under those two human rights instruments, states parties to those instruments, to those conventions, are obliged to report every 4 or 5 years on the measures they have taken to implement their obligations. And those reports are then examined by that committee composed of independent experts. And that is being done in an open meeting of those committees. They are meeting in either New York or Geneva, in an open meeting where the state party is represented by a delegation, quite often high-level delegation. In preparing itself for such a dialogue with a state party on that day, the committee is working in tandem with a number of specialized agencies, but also with the High Commissioner for Human Rights, on the issue of nationality, on the issue of statelessness, on the issue of refugees, asylum seekers, we always get, and that is true both for the Human Rights Committee and the CEDAW Committee, confidential information of the High Commissioner for Refugees office. And that is very important for us, because the High Commissioner for Refugees is a body which is most aware of the problems relating to statelessness. That helps us in raising the appropriate and pertinent questions on this particular issue. As I indicated, the CEDAW Convention provides explicitly, and in that respect it's a unique convention, explicitly for the issue, for obligations of states parties to achieve the principle of equality of women and men in the context of nationality laws. So there is a basis in the convention itself to scrutinize the performance of states. We do that on the basis of the information delivered to us by the High Commissioner for Refugees, but also on the information of non-governmental organizations, domestic and international non-governmental organizations. After a full day of discussions, we assess the performance of the state on the basis of its report, on the basis of the oral examination of the report, and we come to a list of concerns and recommendations. Every concern is coupled with a recommendation. A recommendation not binding for the state, but a measure, an instrument to put pressure on states. So in almost all concluding observations, there are references to the nationality issue, and states are urged, encouraged, assisted in addressing that issue in conformity with their obligations under the convention. Those recommendations, as I said before, those recommendations are not binding. But that's not so important, although I'm a lawyer, it's not so important, because we do know that such recommendations are going to play a life of their own, are going to play a life in the hands of the High Commissioner for Refugees, who can use our recommendations in the context of their own work, in the hands of other specialized agencies such as UNESCO, UNICEF and others, which can use those recommendations in order to have an impact on the policies of the state party concerned, but also by non-governmental organizations, by domestic non-governmental organizations who can use the recommendations in order to call on their governments, on their parliaments, to comply with international obligations. And that, I think, is the value. I do submit, and I would be interested to know what Rada thinks. I do think that the CEDAW committee is the only committee giving systematic attention to the issue of nationality laws and the issue of gender equality in the context of those laws. You don't see that with any other human rights treaty body, including the Human Rights Committee. The Human Rights Committee can address the issue, again, on the basis of information by the High Commissioner for Refugees. But there are so many other issues drawing and calling for the attention of the Human Rights Committee. So we address the issue of double nationality, of statelessness, and call on states to improve their record, but we do not do it in the same detailed way as the CEDAW Committee. On the issue of reservations, very briefly, I do think that non-governmental organizations, academic institutions, or particular non-governmental organizations should not be too legalistic in their approach of governments. It's more for us, I think, to say that the reservation is incompatible with the object and purpose and therefore impermissible. But non-governmental organizations can use that argument to say to their states, it's incompatible. See what the international community, a body of independent experts coming from all parts of the world, is thinking about those reservations. Please withdraw them. So also pressure from inside, and that's important on the issue of reservations. And for the rest, the issue of reservations, to a large extent, I've noted, having an academic background, but having become more and more a practitioner of human rights law, the issue of reservations is to a large extent very much an academic issue.
So, Rada, I wanted to ask if you wanted to perhaps reflect on some of the same questions, and I also wanted to ask you to tell us a little bit more about what the UN Refugee Agency, which also has a mandate for statelessness, is doing to address this. Obviously, you've already talked about the study that you've recently undertaken, but sort of plans for the near future or other activities that you've undertaken? Thanks.
I think that's a good question, and something that we've been very quiet about so far on this panel, which is that UNHCR does not have a mandate to work on gender discrimination issues or women's rights issues generally. It has a mandate to work on refugee issues, and in the context that we're speaking about here, on statelessness. It has an explicit mandate to protect stateless persons and to prevent and reduce statelessness. And that's where the link with gender discrimination comes in, because if you remove gender discrimination from nationality laws, you are preventing and reducing statelessness, particularly if you look at the kind of provision that I spoke about with Morocco, where if you go back retroactively, you can reduce the number of stateless persons in addition to preventing it from occurring in the first place. So that's where the link is. Now, for those of you who are not so aware of UNHCR's statelessness mandate, we have two conventions, two international conventions that we are responsible for, I guess, in terms of promoting the obligations contained therein, and in terms of encouraging states to comply with international obligations for the protection of stateless persons and the reduction and prevention of statelessness. Interestingly, neither of those conventions, one which is the Convention on the Protection, one on the Status of Stateless Persons from 1954, and the other one from 1961 on the Prevention of Statelessness, neither of them tackle gender discrimination head-on as a ground of discrimination. The 1954 Convention, in its Article 3, prioritizes discrimination on the grounds of race, religion, and country of origin, but is silent on the issue of gender discrimination. Now, some would say that this is because these conventions were developed before, for example, CEDAW, but there was a convention in 1957 on the status of married women, which did look at specifically the issue that's picked up in Article 9.1 of the CEDAW Convention relating to the the change, retention, and acquisition of nationality of women. So I'm not sure if that argument really stacks up when you look at the fact that the 1961 Convention came after 1957, obviously, and possibly could have incorporated some of these gender discriminatory elements or prevention of gender discrimination as a way of preventing statelessness within it. But in terms of the work that UNHCR does, it sees a very direct link between achieving gender equality in nationality laws and the prevention of statelessness. And the activities that we undertake to that end are very much directed in the first instance at states, and ensuring that states are examining their nationality laws and changing them to be in conformity with Article 9 of CEDAW as a means to achieving their obligations under the 1961 Convention on the Prevention of Statelessness. And we're at pains now to draw that link. What was interesting about the recent study or dialogue that we did was that when we spoke with women's rights organizations, very, very few of them were aware of the fact that there even was a statelessness convention, that there was an international organization mandate to work on the prevention of these issues. Interestingly, and in contrast, the actual women whose children were stateless, when we spoke to them, they too were not aware that there were conventions, but they were acutely aware that the need for them to have the right to pass on their nationality was to prevent the statelessness status of their children. They weren't so concerned for themselves having an equal right with men, but they were terribly concerned about the fact that the impact was the statelessness of their children. So what we got from that study was the need to highlight the links between gender discrimination and statelessness, to ensure that the activities, say, undertaken by CEDAW and the working group that's recently been established against discrimination in law and practice, that these various UN organizations or bodies and agencies work closely together, because only then do the synergies between different areas come together to ensure that essentially two issues are being tackled, one of gender discrimination and statelessness at the same time. I think that there's also a huge need from a UNHCR perspective to gather more data. There's a lack of empirical data on the issue, which makes it much harder to confront a state, to say, this is a significant problem in your country, which is being caused by your law. We have counted X number of stateless children who are only stateless because you don't give the women of your country the right to pass on their nationality. If we had that data, we would have some pretty compelling arguments to make. So I think that that's another area in which the agency is looking to expand its work, to undertake mapping of stateless populations, and also to understand the impacts of statelessness. It's all very well to say that this is a stateless person, but to a government official, that might not mean much. It's stories like those, and hearing people tell their stories about the impacts on their lives that makes a difference. So I think both quantitative and qualitative studies on the impact of gender discrimination and nationality laws is something that the agency is keen to work on.
Great, thank you very much. I want to open up for questions from the audience, and in sort of real Jerry Springer spirit, I'll take on the audience myself. So if you could just introduce yourselves. It's absolutely fine to ask your questions in Dutch if you prefer that. Laura has promised that she will translate in that case. But yeah, just introduce yourself, and if you have a question, you can either direct it to the entire panel, or if you have a question to one specific panelist, please say so as well. Thank you.
Thank you very much. My name is Connie Rijken. I work here for the Tilburg Law School for the European and International Law Department. And I actually want to focus a bit, my question focuses a bit on the consequences of, the gender discrimination and citizenship, especially if people marry a man, or if a woman marries a man and loses her nationality. Is there a possibility to retain her nationality after, for instance, a divorce? If this is not the case, then this person is actually caught in a trap, and she might be, find herself in a vulnerable position, and she has no possibility to leave this position. And in relation to that, there is some research already ongoing on the relation between statelessness and trafficking in human beings. And I think especially if this is not possible to leave a situation of a violent situation, or maybe a situation where a woman is exploited, this might lead to an increase in vulnerability for trafficking in human beings. So maybe you have come across, especially Professor Flinsemon and maybe Rada, also in your daily work, whether you come across these stories. Well, thank you.
Yeah, perhaps I first should say something about this possibility to reacquire citizenship after divorce or after the death of the husband. That is a very important point of concern. Already since a very long period. The 1930 Convention on Issues of Nationality already prescribes that a person who has lost the nationality by marriage should be able to reacquire the citizenship after a divorce or after the death of the husband. And that's, of course, in particular in cases of divorce, we can imagine that it is of paramount importance. Even if you've not got stateless, but you acquired the nationality of the husband and you divorce, it is quite likely that one of your options is to go back to your home country, but then you need the citizenship of that country. There are a lot of nationality acts which provide that women who lost their citizenship by marriage, before the introduction of the equal treatment of men and women in nationality law, have the option to reacquire the nationality, the original nationality, after the dissolution of the marriage. For example, in the Netherlands, women who married before 1985 and lost for the one or the other reason, I do not elaborate on the details now, their nationality and acquired the nationality of the husband, have the possibility to reacquire Netherlands nationality within a period of 1 year after the dissolution of the marriage, and then this reacquisition has retroactivity until the moment of the dissolution of the marriage. And that implies that she immediately can enter the country. Although I have to admit, since a couple of years, there is a public policy check. And therefore, if she has a criminal record, it could be difficult. That is a negative point introduced recently. But you are completely right that the question that the nationality is lost, yeah, can have as an implication that the women get more vulnerable.
I have an example from Vietnam. You may have heard of this phenomenon called the Vietnamese brides, but it was an issue that kind of reached its climax in the early 2000s and was to do with, I suppose, partly the effects of globalization and much more intermarriage within the region, the Asia-Pacific and the Asian region, and saw a situation where particularly poor Vietnamese women were receiving marriage offers from places like Hong Kong or Taiwan, China, a large number of brides going over to other countries, and finding that in order to acquire the husband's nationality, again, part of this sort of unity, family unity idea, or the husband simply requiring that the woman acquire his nationality, a provision in the husband's nationality law being that in order to acquire, say, for example, Taiwanese nationality, the woman would have to first renounce her Vietnamese nationality. And for many of these women being in a position of vulnerability and sometimes taking up these marriage proposals, not actually knowing the man particularly well, finding that they would renounce their nationality in a bid to acquire their husband's nationality, and then finding themselves abandoned or left before the nationality was acquired, the new nationality was acquired, the marriage breaking down, and the women then being left stateless as a result because they would not be able to pick up their Vietnamese nationality under the laws of that country. Now, there was a reform in 2009 where the issue had become so big that the government actually reformed its law to allow Vietnamese women to reacquire their nationality, and quite a number of these Vietnamese brides are now in the process of doing that and finally not being stateless anymore.
Precisely on this point, related to the 1957 convention, you mentioned it already before, because on the background of this story you just told is also the 1957 convention, which prescribes that women do not lose their nationality automatically anymore in the case of marriage, but prescribes the facilitated access to the nationality of the husband. And that gives the husband the power to put pressure. And to say, we should have one nationality, it's much cheaper, and then I do not have to pay for your permit anymore, it's much cheaper, use your right. And then in the case of dissolution of the marriage, one gets the huge problems. And it is quite striking, in my opinion, the structure of the 1957 convention is contrary to CEDAW, because it discriminates women indirectly. It gives power to the husband to put pressure on the women to change nationality, with all the consequences of that. And therefore, it is amazing that that the United Nations does not stimulate countries to denounce the 1957 convention. and even still promotes, obviously, the ratification of the 1957 Convention. I counted recently how many countries ratified the 1957 Convention after the CEDAW came in force, and that is, what was it? 20 countries. 20 countries ratified the 1957 Convention after CEDAW came in force in 1981. And I simply do not understand that. I think we should try to promote that the 1957 Convention should be abandoned by the countries.
I would like just to comment on the last statement by René. I found that very interesting. As far as I recall, and I've seen 130 states parties before the Women's Committee, we never recommended the states parties to the Women's Convention to ratify the 1957 Convention, but only the 1954 and 1961 Conventions, but not the 1957. That's one. Secondly, I do think that from an international law perspective, the interpretation of the 1957 Convention should conform with the obligations that the states parties have undertaken under the 1979 Convention. So any interpretation given to the 1957 Convention, which would not conform to the 1979 Women's Convention, would be in itself a violation of the CEDAW Convention. I think that's the international law perspective. The subsequent state practice should color the interpretation of earlier agreements, especially in the case where a particular convention has been ratified by almost all states around the world. On the second part of the question by Connie Rijken, I would like to say, interesting again, that the CEDAW Convention has that unique feature that is also addressing the issue of trafficking. There is no other human rights instrument explicitly focusing on trafficking issues. In this respect, once again, the CEDAW Committee works in tandem with the High Commission for Refugees. In the confidential information that we receive from the High Commissioner for Refugees, also the issue of trafficking, human trafficking women, but also others, but especially trafficking women is raised. But we need more data there. We need more data on the question of whether indeed the statelessness of persons is an important factor in on the issues of human trafficking. I do not know. It's my impression, having seen so many different reports, but I do not know for sure. And there I think we should have more, we should aim at having more concrete input from academic institutions, from non-governmental organizations.
Great. We certainly have time for a few more questions, so.
Thanks, Sebastian. If you could permit me more of an intervention, but I will certainly try and end it with a question. My name is Chris Nash from Asylum Aid, and I'm also here in my capacity as being part of the steering committee of the recently established European Network on Statelessness, which is a network of civil organisations joining together to try and tackle statelessness across Europe through a range of awareness-raising, capacity-building and law and policy activities. And under our law and policy activities, it was interesting and encouraging to hear from RADA at UNHCR about the mapping exercises. I myself, my organisation Asylum Aid, has just completed a joint mapping study in the UK in collaboration with UNHCR, and ENS, the European Network on Statelessness as a whole, stands ready to potentially to support or undertake other mapping exercises. Also, we're very much looking to conduct not only strategic litigation, but also to work with human rights monitoring bodies and to support soft law development, and also to work with other partners such as the Council of Europe, the Organisation for Security and Cooperation in Europe, EU institutions and other national governments and ombudsmen and stakeholders generally on the issue of statelessness. I would finish the plug shortly and finish with a question. The steering committee has just been here in Tilburg meeting. Obviously, Laura van Vaas is a very important member of the steering committee who has very ably hosted us. Other committee members will be here after the event if anyone would be interested to hear about more, and do watch this space. We'll be launching a website later in the year. But the question would be addressed to the whole panel, but perhaps to UNHCR in particular, where you see we could support your statelessness-related activities and add value. But I'd be interested in comments from the whole panel. Thanks.
You've put me on the spot. I think of what I'm aware of what the ENS is doing, it's a fantastic initiative, and one actually that I hope is emulated in other parts of the world, because I think that there is a lot to be gained from pooling expertise on statelessness and action that's occurring in different countries. I think that as kind of regions kind of coalesce in terms of what they do in terms of law and practice, and I suppose it's particularly pertinent in Europe, where there is so much drawn from different jurisdictions. It's particularly important for that expertise to be consolidated and capitalized upon. I think in terms of where UNHCR would see a collaboration with ENS would be in some of the areas that you've sort of already highlighted. I think that the notion of strategic litigation is a very interesting one, and for reasons that probably everyone can appreciate, it's not always appropriate for an international organization to intervene in the same way that perhaps a civil society organization or a group of civil society organizations might be able to intervene. And I think that we can complement each other in terms of the perspectives that we would bring in such a strategic litigation, an international perspective, a domestic perspective, but all headed towards the same goal. So I think that certainly in the past we have collaborated on very few, I have to say, cases in national jurisdictions, but also in the European Court of Human Rights as amicus to the court, but have also worked very closely with the civil society groups that have actually instigated the action. And I think that there is something to be gained from that sort of angle of approaching some of these issues, because there are very clear violations of very specific treaty obligations that can be tackled through this mechanism. I think that's one thing. And I think that the second area is, as we've all sort of noted in this discussion today, the need for more data and the need to be close to the ground in terms of being able to gather that data. And I think that the work that you did through Asylum Aid really produced a groundbreaking mapping study. And if people haven't seen it, then it's on RefWorld, which is UNHCR's sort of refugee support website. You can click on the Statelessness special features page, and there are in fact two mapping studies that have recently been done. One by Chris in Asylum Aid on statelessness in the UK, and another one for the Netherlands, in fact, which are really the first kind of glimpse in a consolidated way of the issue as a whole in the country. And I see us very much collaborating over those sorts of initiatives in the years to come. But also, I think that the discussions that you have as a network will feed in and give us ideas, because we sort of have a fairly full plate and sort of fulfilling our mandate, but always very keen to kind of collaborate on creative and interesting projects. So yes, as you say, watch this space, I think.
Yeah, Kees first.
I would like to echo what Rada said from the perspective of the CEDAW and the Human Rights Committee. Sitting here, I do realize that although I have emphasized the importance of the input of non-governmental organizations in the framework of the activities of both committees, that on the issue of statelessness and nationality, the input of non-governmental organizations has been so far rather restricted. We very much rely there on the input of the High Commissioner for Office. And for that reason, I would like to urge you, if possible, to play a part in the examination of state reports and to provide information. As you know, you don't need consultative status in order to input information on these important issues, and that could very much help the committees in the examination of state reports, but also in the field of litigation. Once again, there was now reference to the European Court of Human Rights, but both the CEDAW committee and the Human Rights Committee also have individual communication procedures. And so where appropriate, I think if you have good cases where all local remedies have been exhausted, it would be important to assist the victims, possible victims, and to submit their cases to the either Human Rights Committee, or if it is gender related, to the CEDAW Committee. You have to choose at least one of the two bodies. And thirdly, as you know, and I find that very interesting, and it's somewhat underutilized, and that is that the CEDAW Committee also has the inquiry procedure. So if it would be possible for a particular country to indicate that there are grave or serious violations of human rights of women from the perspective of statelessness, nationality laws, that could be the trigger for the CEDAW Committee on the basis of its mandate under the optional protocol to start an inquiry procedure. It's not necessarily the most effective procedure, but it's one of those instruments that should be used for the good of women around the world.
I also would like to stress that the cooperation with the UNHCR is very important. Radha just mentioned that in a couple of cases the UNHCR acted as amicus curiae, and that is, I think, a very important approach. Of course, one should not do it too often, but one should do it often enough. I also noticed recently that in a procedure in the Netherlands where a lawyer came with argumentation based on academic publications as well, that a certain provision of the Nationality Act of the Netherlands violates the 1961 Convention. The UNHCR wrote a formal letter to the lawyer involved confirming the interpretation of an article of the 1961 Convention, which made clear that it was not mentioned expressly, but it was absolutely obvious that then the rules in the Netherlands are contrary to the convention. And because we have the system of direct effect of international treaties, then judges cannot apply a certain requirement which exists in the law. I think that's also a very, very interesting method to cooperate with the UNHCR. Then it's not immediately the amicus curiae approach, but it comes very close to it, and perhaps it is even more effective in a lot of cases, in particular in those countries where international treaties have direct effect. By the way, the consequence of that letter was that, as a big surprise, the person who claimed to have an option right on Netherlands nationality because of the statelessness, it was a child brought statelessness in the Netherlands, and the child did not fulfill the criterion that the child was staying lawfully in the Netherlands, and the requirement of lawful stay is not included in the 1961 Convention. Then, as a big surprise, the relevant parent suddenly got a residence permit with a retroactivity of 7 years, and therefore the case did not need to be decided anymore.
All right, I think we have time for 2 more relatively short questions.
Relatively short. I'll try and do my best. My name is Imara Antonius, and I'm currently working for the Home Affairs Department of the Municipality of Utrecht. And I've taken a notice of the UNHCR report on the Netherlands situation, and I just heard Professor René de Groot indeed. And what I'm wondering about is, we've been talking about how gendered is citizenship, so we know which countries actually have discriminatory laws within their national domestic law. And what's the responsibility then for the receiving state, for example, the Netherlands? If people are, for example, registered within the Municipal Basic Administration, GBA, Gemeentebasisadministratie. If there are very much people not registered as stateless, but at least with the nationality unknown. And if we are certain of the discriminatory practices in well, the countries, or the home countries, or the countries of birth, what is then the responsibility of the receiving state when it comes towards these women, maybe their children, or even maybe the third generation?
May I take this question? It depends very much on the facts of the case, but perhaps I should mention that the UNHCR organized last year an expert meeting on the interpretation of the 1961 Convention on fighting cases of statelessness in Dakar. And the conclusions of the Dakar expert meeting are already published on RefWorld, the website of the UNHCR. And the issue of registration of being of unknown nationality is addressed in the Dakar conclusions. Perhaps you saw that already. Of course, the Dakar conclusions focus on the position of the child, because the child has, under circumstances, if the child is stateless, access to the nationality of the country of birth, if it is an otherwise stateless child. Now, we have a lot of cases in the Netherlands where children are registered as of unknown nationality for a much longer period than a couple of years. Now, the maximum period of a residence, which can be required in the 1961 Convention, is 5 years of a residence. And the Dakar conclusions say that registering a child longer than 5 years as of unknown nationality violates the 1961 Convention. And then the logical consequence would be that the child is able to lodge a declaration of option for Netherlands nationality if even after 5 years the child is still registered as of unknown nationality. And if the child is Dutch, the mother can stay also in the country. If that mother has to stay, has to care for the country, the Zambrano decision of the European Court of Justice.
I think that the question you raise is an important one also from the perspective of another set of guidelines and another expert meeting we recently had on the establishment of statelessness determination procedures. And I think that, you know, it's interesting that a lot of countries, not just the Netherlands, have this curious status of unknown nationality. There is no international convention relating to the status of unknown persons. There is an international convention on the status of stateless persons, which Netherlands is a party to and has certain obligations under in terms of protection of these people. So begs the question that if a person is unknown, especially if it's a child, there should be a procedure in place to actually determine, and it might be on the basis that the child's father is unknown. The mother is unable to pass on her nationality because we know which country they've come from, and we know that the laws of that country do not allow her to pass on the nationality. So the child is very likely to be stateless. Now, if you had a statelessness determination procedure in place to actually determine that, you know, based on the links that this child has with, say, the mother's country, the child is in fact stateless, then certain rights and protections need to be afforded to that child. So it's very important to not have this prolonged unknown status, which has no rights flowing from it. So I think that's another point.
So, very last question. Anyone?
Is a question?
Yes, you may.
Yeah, because we did not discuss at all the indirect discrimination of women or men. And I think that also should be a point of attention. May I give you one example? Increasingly, countries formalize integration requirements for naturalization. In the Netherlands, there is a bill pending in Parliament which inter alia introduces the requirement of qualification. Now, I have to explain what it is. Qualification requirement. A person applying for naturalization must demonstrate that he or she is able to earn money. That can be proven on different ways. The easiest way is to say, I worked already for at least 3 years. then it's proven. If you do not have that evidence, you can prove it by showing that you had a certain professional education. And that must be at least 2 years on secondary school professional, vocational training level. And that, I think, discriminates, at least, no, perhaps discriminating is a little bit too quick to say that, but puts women in a less, in a disadvantaged position. It is interesting that the State Committee on Civil Status and Nationality, which exists in the Netherlands, made already that remark at occasion of the publication of a pre-draft for the bill. But the minister, although she is female, did not say anything about this potential indirect discrimination effect for women.
I was not aware, and so I'm most grateful to be here because I learned so much this afternoon. I would like to refer René and others on this particular point to the general obligations that flow from the Convention on Elimination of All Forms of Discrimination Against Women. As you, of course, all know, that particular convention not only obliges states to eliminate direct discrimination, but also indirect discrimination. But especially Article 2 of that particular convention, which is the core of the general legal obligations, has been interpreted by the Women's Committee over the years as requiring from states to always have a gender impact assessment of any new piece of legislation. And if from such a gender impact assessment of legislation it would appear that women are being put in a disadvantageous position, then such legislation should be amended, should be put into conformity with the obligations under the CEDAW Convention. And that's the way to go, I think, to refer to the international obligations and to have a true gender impact assessment to see whether your considerations are adequately based, and then to urge for a revision of the present draft.
All right,
we will do that.
I think on that note, we are getting very close to 4 o'clock, so I'd like to obviously again thank Laura and the Statelessness program for organizing this panel. I'd like to thank our 3 panelists for a fascinating and very interesting discussion, and thank all of you for your questions and for coming. Thanks.
Just very briefly, on behalf of the Statelessness Programme, a massive thank you to all of our panellists today. Case, you may have learned a lot. I've learned a lot as well, again, even though I've been working on this issue for many, many, many years now. A special thanks to Sebastian for taking on the role of discussion facilitator so competently and guiding us through this afternoon, and also to the rest of my team at the Statelessness Programme for helping to set up this event and making sure that the room is ready and everything is ready for the participants. Anyone who's interested in the background study that Rada was referring to that UNHCR has done that describes some of these gender discriminatory provisions in the nationality laws, we have some copies on the table by the entrance, so please feel free to pick up a copy on your way out. To echo Chris's plug, the European Network on Statelessness is meeting here in Tilburg this week. In fact, they're all about to fly home again. So if you do want to meet someone who is part of this network and to ask them questions about what they intend to be doing and perhaps what you can do to help, then please come along. We'll be in the Esplanade Cafe for about an hour immediately following this event. We'd even be happy to offer you a drink while you wait for a chance to chat to them. So thank you so much for your interest in everything today, and we hope to see you again next time we have an event like this.